Hello, this is Scott Horton. We're getting ready for today's webinar. Don't forget to warn. We have just a couple of minutes until the scheduled start time, so the room is now open. We're going to let attendees get in, and then we will get started in just a couple of minutes. People are starting to join us. Hello, this is Scott Horton. You should have the cover slide for the presentation on your screen. Don't forget to warn. You should also have access to a chat window. That's where you'll be able to ask questions throughout the presentation, although I will probably reserve answering most of them until the end. We will get started in just a couple of moments as we wait for everyone to join. Again, welcome to those who are just joining. We will get started in about another minute or two as soon as everyone's had an opportunity to enter the webinar. I am Scott Horton. I will be presenting today. We will go about an hour, including a question and answer period at the end. I will stay longer if necessary to answer questions, but we will try to get you on your way if that's all the time you're able to have with us today. You, again, should have the cover slide for the presentation. Don't forget to warn on your screen and access to a chat window where you can ask any questions that come up as I go through this. I will answer a question as we go if I feel it'll be helpful at that point, but I will mostly reserve answering questions until the end of the presentation. We are coming just up on our start time, so I will go ahead with a couple of introductory remarks. The presentation slides will be available to everyone. I will post a link to that at the end, and if you have registered for this webinar and your email is on file, then you will automatically receive an email probably tomorrow that will give you the link to the slides if you don't have time or don't want to download them later when I post that link. Again, there's the chat window. That is where you can type in questions that you have. I encourage you to type in questions as you have them, even though I may not get to them until the end of the presentation, but obviously we don't want you to forget what you wanted to ask. I will note that although I am an attorney in practice labor and employment law in New York State and represent clients on many employment law issues, including those related to today's topic, this presentation cannot be considered legal advice. I'm not familiar with your individual circumstances, so even if you do ask questions and provide some details, I won't be able to give you legal advice. There will be no attorney-client privilege either, so keep that in mind as you're asking questions. Don't ask anything that would be uncomfortable if others in the webinar who see your name, for example, or based on the information you're providing might know what you are asking about. Try to remind you about that at the end, but again, ask questions as we go. We'll answer them when we get to them. With that, I want to go ahead and get started. Thank you all for signing up and joining the webinar. Today's topic is don't forget to warn employer notice obligations for reductions in force. My name is Scott Horton. I am the owner and founding attorney of Horton Law PLLC, which is a law firm in Orchard Park, New York, but I do have clients throughout the state of New York, including clients in New York who have employees elsewhere. I think most of you who have registered for this webinar are within the state of New York. Others of you, or some of you, I should say, may have employees that you're responsible for outside of the state of New York. Just know that I am going to be talking about both a federal law and the New York WARN law in particular detail, trying to compare and contrast those as we go. But if you have employees and facilities and other plants where these issues may come up, then there might be additional state laws in those states that you need to consider. I will later put up a slide that shows you what those states are as of my best information at last check. With that, I want to get started. So there are a lot of pieces to the WARN acts, and these are federal and state laws that have been around now in New York for about 10 years and for, I believe, about 30 years at the federal level. But the first question for us to consider is who is covered by the laws in the first place? And what we are most specifically talking about, generically speaking, is employers who are contemplating closing a plant or facility, relocating or moving their operations, reducing employee hours, at least in some sort of broad sense, which we'll go into in more detail, not just every time you're going to change someone's schedule. Temporary layoffs that affect a number of employees. So even though employees might be eligible to return to work at some point in the future, if the layoff extends long enough, there might be obligations under these laws. And situations, most notably when a company is terminating a number of employees. We'll get to what those numbers are. And I will say now that the issues we're going to be discussing and the laws we're going to be talking about get very detailed. I'm going to do my best to point out some of the major requirements and parameters. If you have specific questions, ask those. But otherwise, recognize that there is a lot of nuance in this area, and we may not be able to address every situation that might come up under these laws. So with that being sort of a general background of what types of situations might cause you to wonder about these types of laws, the more specific types of employer entities that are covered will prove to be sufficiently large business enterprises. Business enterprise is the term used by both the federal and New York WARN Acts. If you're in another state and looking at their state WARN laws, they might use other terms. But as those terms have been interpreted, they include generally private employers, and we'll get to the size in a minute. Not all private employers, but sufficiently large ones. And then under the federal WARN law, it is possible that some public entities, meaning agencies or authorities of some kind of government affiliation or ownership, could possibly be covered by the WARN law. In New York, there's a pretty specific carve out. So under the New York law, there would be no coverage of any public entities. And even under federal law, if you're talking about a pretty traditional public entity, such as a city or town, county, or something like that, state, then there would be no likely coverage under these laws. It would have to be some sort of special standalone organization that is nonetheless perhaps government funded or controlled, but doesn't actually perform basic governmental functions like cities, towns, villages, counties, states, etc. do. Okay, so how big do you have to be subject to the WARN laws in the first place? Under the federal law, which again has been in effect for about 30 years, a company would have to have at least 100 employees in the United States. The New York law for the last 10 years has applied to companies with as few as 50 employees in New York. If you are a New York employer but also have employees in other states, for purposes of the New York WARN law, you would focus just on the New York employees. Might be some complexity as to which employee counts as a New York employee or which doesn't, and we might address that in a sense later. But that's sort of the broad parameters. Now, before I go on, just keep in mind that whenever I'm talking about the New York Warren Law applying, that doesn't automatically mean that the federal law doesn't also separately apply. If you have 100 or more employees and 50 or more employees in New York State, and you're otherwise doing things that would come into coverage under the law, then your obligation could be to comply with both laws separately. But fortunately, the laws are very similar in what they require, or at least the New York law, if you're complying with that, with the lower threshold, and also needing to comply with the federal law, there's not that much more you would need to do to comply with the federal law. But they are separate laws, and there are some distinctions that we'll discuss. And before we go any further, we need to talk about what it is specifically that the Warren Acts require. And to do that, I want to go through some of the key terms and parameters that are used under these laws and that we'll be talking about throughout the rest of the presentation. So again, the Warren laws are a federal law, and there are similar state laws in many states, including New York. Warren itself stands for Worker Adjustment and Retraining Notification Acts. These laws require companies to provide notice before taking certain actions to reduce the size of their workforce. We're about to get into more details about which certain actions are covered. And as I was just alluding to, the New York law in just about every respect, where there's any differences anyway, imposes greater burdens than the federal law. So usually if both apply, complying with New York law will at least substantially satisfy all requirements of the federal law. But you would need to make sure that you're separately complying. We'll get to this later, but the primary practical difference is under federal law, you do need to send at least one or two additional notices to certain government entities. But by and large, what will cause you to have to send notice and the content of the notice you'll have to send would be virtually identical. At least you would do enough under the New York law that you would also meet the federal law in just about every case. One of the biggest differences between the federal and New York Warren laws is the numbers that get relied upon for different components. And one of those is the period of time in advance that the employer must send out notices. Again, we'll get to who the notices go to and what they contain later, but when you have to send Warren notices under the New York law, you need to send them 90 days in advance, or at least that's the default, unless there's an exception. Under the federal law, only 60 days notice was required. So when New York passed its law, again, I think it was 2008, or when it took effect back then, that really increased the obligation that New York employers previously had pretty significantly, where you only had to give 60 days notice before. Now you have to give 90 days. Frankly, there are many situations where 60 days notice in and of itself is difficult to comply with. 90 days made it only that much more so. So let's talk about what it is that ultimately triggers the obligation to give notices in the first place. So there are a few terms you need to understand because they're kind of peculiar terms that are used under these laws, but without understanding the terms, there's no way to comply with their the responsibilities that employers have. So the first term is employment loss. Before I go into this too specifically, I will just editorialize a little bit that the New York statute is largely copied from the federal statute, but they threw in some concepts from a couple of other states that already had WARN laws at the time, including California, and changed a couple other words here and there that in the aggregate made the New York statute more confusing than it probably should have been. So there are some inconsistencies in the definitions under the law, and so there are some gray areas. There hasn't been that much litigation under the New York WARN law, but I'm going to basically give you my best description of what these terms all likely mean in practice. Employment loss then under both the state and federal statute generally include things on the slide, employment terminations, other than discharges for cause, voluntary departures, or retirements. So in other words, something that would be based on the employer downsizing versus we're letting you go because you engaged in some inappropriate conduct or the employee chooses to leave for whatever reason. Employment loss also includes temporary and partial employment losses in the sense of B and C here, layoffs longer than 6 months. So even if it's anticipated that the employee would be allowed to return to work, if that's not going to be until more than 6 months down the road, then they suffer an employment loss for WARN purposes. Jumping ahead a second, the employment losses, the numbers of those in a time period is going to be what determines when and whether employers have to issue the WARN notices. And then finally, even for employees who don't get days or time off as a result of the employment loss, the reduction in their hours of work by more than 50% for a 6-month period would also qualify as employment loss. So if a factory goes from operating so that everybody works 40 or 50 hours a week down to a point where everyone works 20 hours a week indefinitely to last more than 6 months, then that would qualify as an employment loss. And it doesn't matter if it's everyone in the factory, but in each case where that would be the reality, that would qualify as an employment loss for WARN purposes. Okay, now we know what an employment loss is. We also need to know what affected employees means. And affected employees are employees who may reasonably be expected to experience an employment loss as a consequence of a proposed plant closing or mass layoff. I'm about to tell you what plant closing and mass layoff mean, but for now, this generally means that if there is some large reduction in force that might create a WARN obligation, to determine whether it creates a WARN obligation, you need to look at employment losses. But once you determine that there is a WARN notice triggering event, then you will need to look at affected employees, because those are the people who will both need to receive notices under the law and will be included in reference in other notices that go to certain government officials. I put on this slide because it's going to be important. All these things are circular and intertwined. That affected employees does include part-time employees. Before I explain why that's important, let me tell you how these laws define part-time employee, because it's probably not the way that most of your companies or companies you work with define part-time employee for most circumstances. But under these laws, an employee is part-time if they either A, are employed for an average of less than 20 hours per week, or B, have worked or have been employed for fewer than 6 of the 12 months preceding the date on which notice is required. So A is the example of anyone who works less than 20 hours a week. They're part-time. Many companies, I imagine, would consider someone working 30 hours a week or 25 hours a week, for example, to be part-time, but not the case under these laws. And the second component is particularly interesting as a definition of part-time because it actually includes people who work 40 plus hours per week who just have not been employed for at least 6 months. So short-term employees, even though they're full-time and permanent, in the sense of there's no temporary duration to their employment, could still qualify at a given time as part-time employees, and that will become relevant in many situations for reasons we're about to discuss. Reminder that the slides will be made available at the end, so appreciate you trying to take notes, but if you want to have a copy of this, you will be able to get that. Also, feel free to start asking questions as you think of them, although I will probably not answer most until the end. So here's where we really get into determining, okay, we know there might be a situation where we have to send notices, but how do we know if such a situation exists? You're really going to be looking for plant closings or mass layoffs, as those terms are defined under the WARN Acts. A plant closing refers to the situation where an employment site is being shut down. So the facility, or maybe in some cases operating unit or something like that, is being shut down permanently and will result in an employment loss for 25 in New York or 50 under the federal law or more employees during a 30-day period. So I try to do some color coding here within this slide to make it easy to track, as you'll see in further slides. But the important thing is the site's being closed down and a certain number of employees will lose their jobs or suffer an employment loss, which, as I discussed before, theoretically could include a 6-month layoff or reduction in hours worked. Most cases that won't be too applicable in the event of a plant closing because the site's being shut down permanently. The federal law that's been in place for much longer had a 50 employee employment loss threshold. New York cut that in half. Most of the numbers you'll see New York changed in whichever way would result in longer or more notices being given and being given more in advance. So in this case, the threshold is only 25 employees in New York. There's an asterisk here because it is important to note that these counts exclude part-time employees. So if you had 80 employees who only work 15 hours a week and 20 employees who qualify as not part-time, they work a full 40-hour week, and you shut down the facility and terminate all of those employees, that apparently would not, assuming there's not some other interesting details that we're missing, qualify as a plant closing because there would not be 25 non-part-time employees suffering an employment loss. The statute actually here refers to this 30-day period to cover the situation where not everyone loses their job on the same day, but maybe we're going to phase it over a few weeks. You still aggregate those. I'm going to redefine 30 days for you in a few minutes, so stay tuned for that. Mass layoff is the other big category of event that would require WARN notices. So a mass layoff could well apply even though the facility is not going to permanently close down or be closed down at all, or any operations be discontinued. Let's take, for example, a large factory that is going to reduce its production, but still continue to produce nonetheless. Here, we're again talking, for now, by default, about a 30-day period. The numbers change and they get larger. So there is a flat threshold of 250 employees suffering employment loss under state law or 500 under federal law. If you reach that threshold, and again, this excludes part-time employees, then there is a mass layoff and notices would need to be given, barring some other exceptional circumstances, some of which we will get into. If there are less than those numbers under the respective laws, then the question is, are there nonetheless at least 25 or 50 under the state and federal laws respectively? And then if so, do the number of employees count as at least 33%, 1/3 of the active workforce? Again, all excluding part-time employees. So this is a situation where, let's say, under the New York law, you have 200 employees in a facility. You are going to let go 40 of them permanently. That is higher than 25, but you haven't closed the plant, so it's not a plant closing. You look at the mass layoff rules. Well, 40 out of 200 does not get you to the 33% threshold, so no obligation. So there is some proportionality at stake in the event of a mass layoff, but not a plant closing. Plant closing essentially assumes that it's 100% anyway. The 250 or 500 thresholds are there for situations where, well, okay, let's just say it's a really huge operation, such that 250 or 500 wouldn't qualify as a third of the workforce. That's still large enough that Congress and the New York legislature feel is appropriate to require the employer to give these notices. So we do have a question. I'm going to save that one for the end, but I appreciate it. And if you have any more questions, keep adding them in as we go. Now, I mentioned before that the New York statute leaves a little bit to be desired in some areas with respect to the carryover from the federal statute and other statutes that it borrowed from. And here's one of those areas. In addition to plant closings and mass layoffs, which are the only notice triggering events under the Federal WARN Act, the State WARN Act introduced this concept of relocation. Having analyzed these in detail back when the statute came out, I believe relocation is a concept borrowed over from the California WARN Act, but they didn't borrow other portions of the California WARN Act that makes relocation make more sense in that context than it does under the New York statute. What it is defined to mean under New York law is all or substantially all of the employer's operations will move to a different location 50 miles or more away from the original site, and 25 or more employees lose their job. There's actually not a 25 or more employee lose their job provision in the statute, but it seems pretty clear, including through the regulations from New York State, that they didn't intend for employers who happen to have 25 or 50 employees in the state, but at one location only have, say, 5, 10, or 20 employees, and then relocate that operation 50 or more miles away. It doesn't seem that anybody really believed that the legislature meant for that to trigger WARN notices to those 5, 10, 15, 20 employees, but that really the 25 employee minimum from plant closings and mass layoffs should still apply. Assuming the 25 employee threshold applied, then it's not clear that you really need this separate relocation event, because it would also qualify as a plant closing or mass layoff in most cases. This concept does not exist under the Federal WARN Act, but it is something that I guess in the right circumstance, although I haven't seen it and I'm not aware of it having been litigated, it could raise some unique arguments. All right, before we go on to some other aspects of the WARN Acts, I just want to warn you all, pun obviously intended, that I referred to the 30-day period for measuring the numbers of employment loss earlier, and that's the way the statute defines those terms. But if you read the statute further, it turns out that 30 days sometimes, I would say often, actually means 90 days. So what does all this mean? What it means is if in a given month you have laid off or permanently terminated, to make it easier, a certain number of employees, perhaps 20, and then plan 30 days later to lay off another 20 employees, and it's all part of the same reduction program, plan, whatever, to right size your workforce, for example, then that would likely still be covered as an event for which you have to give notice, in which case you would have to give notice in New York 90 days before the first employee is affected back in the first month, even though you won't reach the 25-person threshold until sometime in the second or third month. So while the default definitions say 30 days, it's really 90 days unless the employer can show that there's two or more separate groups within the 90-day window that are caused by different circumstances. So, for example, if you had two different departments doing two entirely different things in your organization and you had to make reductions in month one in one department or group because of a certain change in business, and then a couple months later there's an entirely separate change in business, loss of a customer, or hypothetically you've lost a patent suit, you can no longer produce this different object or something like that, and you have to separately lay off or terminate employees in that department, then you might be able to show that only 30-day windows are relevant. So again, this gets pretty complicated, but I would just say for starters, when you're looking for those in New York 25 employment losses to see if you might have a notice obligation, you should probably start at looking at a 90-day window and then look for exceptions and carve out, working back from that. Okay, so we kind of have a, who, what, where, when, all of that going on here. So let's look at where. There are, as I said, other state WARN laws. New York, to my knowledge, is still the most burdensome or most applicable, has the longest notice requirements, all of those types of things. Out of all of these, there was one that just came online at the beginning of this year, which I'm not particularly familiar with. I think that was Delaware. I don't think it would be more restrictive than New York's. But there are, I believe on here, with New York, 21 state WARN laws. Pennsylvania does not have one, but Philadelphia notably does have something along these lines. So if you happen to be now or at some point dealing with a facility in Philadelphia, don't forget to look at the city law there. There might be other locations around the country within states that have similar laws or provisions. And I will say that what these laws cover varies significantly from one state to the next. Many, maybe most, are patterned after the Federal WARN Act, just with some state-specific nuances, but some others don't really operate on the same principles as the Federal WARN Act, but nonetheless require some sort of notice related to employee terminations. But even assuming we're talking about the New York or Federal WARN Acts, the important where in determining whether notices need to be given is always a single site of employment, while the number of employees that the business enterprise has on the state or national level is relevant to coverage in the first place as to whether the statute applies, determining whether there is a mass layoff or plant closing is based on a single site of employment. Not to say the same employer couldn't be making enough employment losses at two different sites to where they would have separate WARN notice obligations, but they would measure each separately in most cases. And I say in most cases, here's some nuances. So it's either a single location, which makes life easy, or a group of contiguous locations. So this would be, for example, if you have offices throughout an office park, but say there's a couple buildings and not all of your employees work in the same building. Possibly even, a situation where you have an office on one side of the street and a warehouse or production facility on the other side of the street. Some of those types of things are going to still qualify as a single site of employment in most cases, even though it's not the same physical building. We're not going to get hung up on nuances as to, well, if we have an underground tunnel that connects these two buildings, is it a single site of employment versus if you have to walk outside to get from one to the next. If they're that close together, they're probably going to qualify as a single site of employment. If you have multiple locations that are further apart, they could still be considered a single site of employment if they are in a reasonable geographic proximity, used for the same purpose, and share the same staff or equipment. It's pretty rare to have such geographically separate but proximate locations considered a single site of employment. You really would need to have staff interchange or equipment interchange. I guess an example might be if you had transportation company and you had drivers in two different locations, a couple blocks apart, and the drivers could report to either or both locations on a given day to pick up a new truck with a different load or something like that. The logistics are the same over the two operations, then maybe that would be a scenario where you'd look at the two sites versus each of them separately. I mean, really in that situation, you might have a hard time figuring out who to count if the same employees really work more or less evenly at the same at each of multiple locations. A couple other notes real quick. The same building could be multiple sites, multiple single sites of employment if independent employers operate there. So if you have an office building, each different company operating within the same building, would have its own single site of employment. It's not just that you count all the employees in the building. That should be fairly obvious. Maybe slightly less obvious would be if you did have a factory where you brought in enough workers from another company that did, say, special finishing on some product that your company prepares. I mean, it's possible that at some point you would actually have two employers having their employees work together within the same building, but there still could be two separate single sites, really based on the fact that there are separate employers. And the single site of employment for employees who work remotely is either and or the site to which they are assigned, from which their work is assigned, or to which they report. I'm sure there could be scenarios where not all of those things line up together to where it gets complicated to determine which site someone should be counted at. But, generally speaking, if someone works from their home but goes into the same office once a week and gets their assignments from that office, etc., then the office is likely to be considered their single site of employment, not their personal home, so you don't get to exclude them just because they usually telecommute. We'll quickly hit the why on all of this, both why do these laws exist and why do companies need to comply with them. The intent of the act's not too hard to figure out. It's to give employees more time to prepare for layoffs and increase their chances of finding a new job. There are regional rapid response teams, which might, for example, include the Department of Labor in New York, that help aid the affected employees with job placement assistance, job referral, job fairs, resume preparation, I think that's a typo there, sorry, job market information, and career advice and training options. Now, at least this is the intent of the law, and this is a significant reason why the laws require notice to be given to certain government officials. That being said, there are certainly many WARN notices sent in that don't result in any significant government response. Just because you say I'm closing down my 27 employee office in whichever town in New York, if that's not top of someone's priority, that might not result in much response at all. But the larger the operation is and the bigger impact it's going to have in the community, more likely that someone in the government will actually get motivated to get involved, whether that be to try to stop the reduction from happening in the first place, say by providing some funding or etc., or at least in trying to make sure that the employees are able to get new jobs sooner rather than later, which in and of itself can actually benefit the employer that's letting them go, because the sooner they get new jobs, the less the unemployment impact would be on their old employer. So, again, easy to understand from the employee standpoint and maybe from the community standpoint why this is helpful. I can say from, representing companies that it's not always helpful for companies to have to comply, but they nonetheless have to comply because basically it's pretty expensive if they don't. And a lot of people could get upset, including, for example, the government, and they can impose fines in addition to liability to individual employees who might go to attorneys who might get interested because, among other things, they might be able to recover their attorney's fees and going after companies who didn't provide WARN notices. So what are the consequences? Damages to each employee who should have received notice, which includes up to 60 days pay and benefits. It's kind of interesting. Under the federal law, there was a 60-day notice period and a 60-day damage period. Kind of makes sense. You didn't give somebody notice, and that should have given them 60 days warning that they were going to lose their job. Well, you now have to pay them 60 days pay and benefits, in a sense, as if you are then giving them you gave them notice at the point in time which you finally took the job action. But under the New York state law, you have to give 90 days notice, but the damages are still capped at 60 days. Don't know whether that was intentional or they just forgot to change a digit when they transposed some things from the federal to state statute. But technically there is that loophole that by not giving 90 days notice in New York, you only have to pay 60 days pay and benefits. Employees who do hire attorneys to litigate these claims can also recover their attorney's fees on top of that 60 days pay and benefit. In addition, there can be civil penalties of $500 per day of violation. The slightly fortunate thing is it's not $500 per employee who didn't get notice, so it's capped at the 60-day violation period. So if you didn't give notices at all and were found guilty for having not done so, then you could be required to pay a $30,000 fine on top of the pay and benefit to employees. Of course, if there's a large enough number of employees, and usually there would have to be at least 25, that 60-day pay and benefit could be much more substantial than the $30,000 fine. But they're both there. There are provisions in the state law that say, you aren't really going to be hit for this twice under both the federal and state WARN Acts. So even though theoretically you could violate both simultaneously, if you're covered by the federal law and don't comply with the state law, you are basically protected to only be out one set of damages. I put in green on this slide that there is this possibility that, in the right situations, employers would essentially have the choice to either pay or give notice, because, the penalty for not giving 90 days notice even is 60 days pay and benefits. If the company just decided it's so problematic for us for whatever reason to give notice, then we will just wait, terminate the employees, and then pay them the equivalent of 60 days pay and benefits each. Now, this could essentially be severance pay, but you couldn't require them to sign a waiver, for example, in exchange for the money, or else you would not cut off your liability under the WARN Acts. But if you do timely pay the 60 days pay and benefit, then the company might be protected from the civil penalties of $500 per day, and essentially there would be no remaining liability. So certainly consult with your own attorney before you take that approach, but it is, I don't think it's necessarily a loophole in the law, but it's sort of a fail-safe way of saying, even if the company intentionally did it, as long as the employees get their 60 days worth of pay and benefits, we're not too upset about the violation. All right, with all of that information, now I'm going to talk about, well, how is it that we then comply with the law when we have to and issue notices? First, important to know that notice must go to, under the New York law, affected employees, their union representatives, if there is one, and certain government officials. I said under New York law a second ago, this is generally the requirement under the federal statute as well. The government officials that have to receive notice are a little bit different under the two statutes, although there's some overlap. But the only real nuance here is the federal statute didn't require separate notices to individual employees. If there was a union representative, you could just provide it to the union representative in lieu of directly communicating with the employees, but the state law specifies that the employer must notify both the union and each of the affected employees. Important under both laws, affected employees, again, does include part-time employees expected to suffer employment losses. So if you remember back, I made a big point to note the part-time employees, which actually can include some full-time employees who haven't worked there very long, but nonetheless from that, the part-time employees don't count in determining whether you have to give notice, but if you do have enough non-part-time employees to have to give notice, then you also have to give notice to the part-time employees who would also suffer employment losses as a result of the mass layoff or plant closing. Notices to government officials, for example, will include lists and identification of who the affected employees are, but otherwise they largely contain the same type of information as what goes to the individual employees, which you see on this slide. So you have to include things like the expected date of their employment loss. Oh, okay. Yeah, the effective date of the first employment loss and the employee's particular date of employment loss. So if an employee is scheduled to be in, sort of round 2, you still have to tell them these are going to start on this date, and then your expected termination date will be this other date. You have to describe whether it's permanent or temporary. Um, keep in mind that although most of the employment loss scenarios are permanent loss of employment, you could have some employees who are affected by way of 6-month layoff or reduction in hours of work that is not intended to be permanent, and you would have to explain that to the extent you can. Whether bumping rights exist, this is under both the federal and New York statute, and what bumping rights mean, will some more senior person have the ability to displace a less senior person. Often in a non-union setting, there's just no bumping right to deal with. Plant closings, there usually wouldn't be bumping rights because everyone is losing their job. If there are seniority issues, and that means that there might be union issues, it is possible that there would be issues that have to be negotiated with the union. The union can't negotiate away your right to or your obligation to provide the notices if the law otherwise requires it, however. But you might be obligated in some cases to at least negotiate over the effects of your reduction in force, which you might or might not be able to or need to do before you issue the WARN notices. The other wrinkle on the WARN notices is if there's information that you don't know at the time you issue the notices. Remember, in New York, that's supposed to be 90 days before the first employment loss happens. Then you have to issue subsequent notices if and when the additional information becomes known, or probably if it materially changes as well. You have to provide the name and number of a company official to contact for more information, and regulations from the state of New York under the New York WARN Act require companies to include information about unemployment insurance, job training, etc. There's actually a paragraph that they include right in the regulations that you should just put right into the notices. That's a minimum requirement. You can give more such information, but that requirement is not something that existed under the Federal WARN Act, and is another one of the differences between the two. But of course, including it in the notice would not be a problem under the Federal WARN Act. You can add additional information there as well, so you don't and normally wouldn't. You don't have to and normally wouldn't give separate notices to separately comply with the two statutes. You also, by the way, don't have to state in the notice that I'm hereby telling you all of this to ensure that I comply with the New York State and Federal Worker Adjustment and Retraining Notification Acts. You just need to give them the information that the laws require. Okay, so we told you a lot of things about when you might have to give notice, what the notice looks like, what happens if you had to give notice and don't. And now I just want to say there are some exceptions. So don't give up entirely and just assume that you always have to give notice at whatever cost. The couple most commonly recognized exceptions are shown here. The faltering company exception is one that only applies to plant closings and only in situations where the company has sought new capital or new business to attempt to stay open, and giving notice would ruin the opportunity to obtain the new capital or business. Suppose, for example, that your company is in negotiations with a significant customer about whether you will or won't retain or get a new contract that would support the business indefinitely going forward. Wouldn't necessarily help the sale process to publicly give notice that the company is on the brink of shutting down. So there is that exception. Of course, if and when the company finds out that it can no longer receive that contract and it has no other basis to rely on this exception, there's nothing else that it's seeking, I probably would have to give notices at that point for whatever period of time left that it could. There's also a more general unforeseeable business circumstances exception, applies both to closings and mass layoffs that are caused by business circumstances that were not reasonably foreseeable when notice would otherwise have been required. But again, employers must give as much notice as possible. So if you have that contract in place and things are going along just great and business is fine, and then all of a sudden the customer calls up and says, yeah, we're going out of business tomorrow, so sorry, you're not going to get those millions of dollars of sales that you thought you were going to get, and then your company has to decide overnight, well, there's really no other reason for us to stay in business, or we're going to have to make significant cuts immediately to do it, then the obligation is not necessarily to wait 90 days before letting any employees go, but to either make the reductions instantly or to give them as much notice, whether that be a month, week, whatever, as you can, to try to comply with the WARN Act to the extent possible. Other potential exceptions, situations where the employer offers to transfer employees to a different work location within a reasonable commuting distance. In that situation, the employees might not count as suffering employment losses. Seasonal and temporary employments, I wrote it this way generically, but seasonal employees might not qualify as suffering employment losses. Might not, even if they suffer employment losses, they might not qualify as part of the calculation for plant closings or mass layoffs, because if they haven't worked 6 months out of the last 12 months, then they would be part-time. Temporary employees, if they were brought on for a specific temporary project of whatever length, they don't qualify for WARN notice in most situations. As long as the project actually ends when it was originally expected to, they had notice at the time they undertook it. Where a closing or mass layoff was a direct result of a natural disaster, such as a flood, earthquake, drought, or storm, obviously there wasn't always a way to predict that. Again, statute does say you should be giving as much notice as possible. Strikes and lockouts related to collective bargaining. Employers have rights to lock out employees as a result of things going on in negotiations with their unions. They don't have to wait and give the 90 days notice under the WARN Acts in those situations generally. And then finally, there's some issues related to selling a company. If the new company is going to come in and continue employment in connection with the sale of a business, then the technical change in ownership wouldn't necessarily trigger an obligation to give notice. There are some parameters for sales of business in the statutes. The seller is generally responsible for notice up to and including the effective date and time of sale. The purchaser becomes responsible after the effective date and time of sale. And these, are the starting point, sort of, but neither party to such an acquisition or merger situation should be just sitting back and hoping the other party does what it's going to have to do. So these should be addressed in the sale negotiations, closing documents, and discussions about, well, is the seller going to issue notices if it is expected that employees are going to lose their job at the time of sale, or if the buyer is going to continue employing people for a short period of time, but then have to terminate them after the transition. Will they be obligated to give notice? And if so, at what point in time and how? Just don't leave these things to chance if you are preparing to be involved in one of these transactions. We're almost done. I'm almost ready for questions. Go ahead and start typing those in. But I do add this slide in here to recap. Under the New York WARN Act, again, a business enterprise is covered if it has 50 or more employees in New York. Notice, if required, has to be given by default at least 90 days in advance, unless one of the exceptions permits a shorter notice period. Assume the notice or the exceptions will be applied narrowly and usually won't protect you. Plant closing, shutdown of the employment site with 25 or more employment losses of non-part-time employees. Mass layoff, you have the 25 or more if it's 33% of the active workforce, or the 250 regardless of the proportion. Under the federal WARN Acts, these numbers all change. The first number in the business enterprise coverage goes to 100. The notice requirement is 60. The plant closing minimum would be 50 employees. Mass layoff, these numbers change to 50 and 500 respectively. So obviously it's important to plan ahead. Consider that 90-day window period if you know you're going to have to let employees go. When it gets really close on the numbers, it can be complicated to calculate out who is a part-time employee and who is not as of which date. But I've been in those situations that can really become important to evaluate. Some employers just decide to give WARN notices even if they don't have to. Both statutes encourage that. But most prefer not to, incur the time and hassle, if nothing else, and the potential public embarrassment and risk of losing employees before they want to by giving unrequired notices. I just throw this in there. I do have a book available on Amazon and other online book services, both in ebook and paperback format. It does cover the New York WARN Act, among many other topics, covering a large span of employment and labor law topics, particular to New York, as well as the general federal statutes that would also apply here. With that, I definitely want to take questions. Although I don't want it to distract you, but maybe while you're thinking of a question, I will put up the link to the slides. So there you have that. You should be able to access the slides through that link. Again, if you're registered, you will get a follow-up email. I'm just gonna give everybody a minute to type in questions while I'm looking at the question or questions that have come in. All right, the first question pertains to leased workers or workers hired through agencies, whether it be a temporary agency or some other arrangement like that, I suppose. The question specifically says they're paid by the agency and asks whether they are included in the definition of employees or affected employees. Of course, this is a question that applies in a lot of contexts under employment law, with a lot of discussion about joint employership these days. It is possible that these types of workers would be considered employees of they're somebody's employees. They might be both the agency and the site owner's employees, for example. And then the question becomes, again, as I was saying before, if you were a temporary agency and you had 50 or more employees at a certain location, that could qualify as a plant closing if they are all let go or transferred. Again, assuming they didn't qualify as part-time employees or temporary employees in the first place, in the sense that if they were only there to complete a 6-month project, when the project comes to an end, there's no notice obligation. But if they're just sort of run-of-the-mill temporary employees that are intermixed with the site owner or the company that operates the site generally, and they're doing the same type of work alongside those people and reporting to the same supervisors, and that and there's no specified time duration, or especially if it's expected that they will work there indefinitely, then it is possible they would be considered the employees even of the site owner if they let go or close down their entire facility, or let go enough employees when aggregated with the leased workers or temp agency placements. But really a lot of the nuances that we touched on throughout this presentation would come into play in those types of scenarios. So that was the only question I've seen come up. If you have one, still go ahead and type it in. I'll stay on for a minute or two. Here's my contact information. If you come up with a question later and want to follow up, or don't feel like asking the question through chat, no, I think we had good turnout here, so I thank you for your interest in the topic. It's one that most companies obviously don't want to have to deal with, not just in the sense that it's a hassle to have to do it, but they don't want to be in a scenario that would cause them to be even considering whether they're obligated to give these types of notices. But business realities being what they are, these things do happen from time to time, and often in especially somewhat larger companies, not even indicating a major problem for the company, but just that something is changing, and now this group of employees is not going to continue in the way that they were working before. But obviously it's a huge potential financial liability if the technicalities aren't satisfied in these scenarios. The other important thing, I hope you picked up in this presentation, is there are a lot of scenarios where companies mistakenly believe they have to issue these notices. I've seen WARN notices issued for a very small number of employees losing their jobs. If you just are letting go a handful of employees in a department for economic reasons, that does not mean automatically that they have to get 90 days notice or 60 days severance pay or anything like that. And even for larger numbers, 25 or more, employers often miss the nuance that part-time employees don't count into the analysis, or they'll miss the fact that when they do, whether they count in the analysis or not, they are entitled to get the notice nonetheless. So don't exclude part-timers from getting notices if they will suffer an employment loss. So still waiting to see if there's any more questions come in. I'll hang on for another minute or two. Otherwise, I thank everyone. You will get an email reminding you of the link to the slides, which you should have access to through here now. I do these webinars on a nearly monthly basis throughout the year. So let me know if there's any topics you would like to see covered. I can't make any promises that I will get to any particular ones at any given time. We'll also try to hit major new issues as they come up. I'm anticipating some new FLSA regulations on overtime coming out this year. The Department of Labor anticipated doing that in March. So that's a big topic that I will likely have a webinar on. So stay tuned and keep track. And with no more questions coming in, I will go ahead and wrap up here. Thank you for your time. Hope you don't find yourself in a WARN situation, but if you do, now you will have a better sense of what to look for and how to proceed. Take care.